let's move on to Julie. Julia,
I'm going to try and share.
Okay. Now you're going to share. You will share, Julia. That's fine.
It's after Tuesday. I'm just like, it's a proper letdown all the way round, isn't it? Really.
Look, I can see legal update. It's absolutely fine. Absolutely fine. Thank you very much.
Wonderful. Then I shall begin.
You always look forward to your legal updates, Julie, because this is obviously something you've got a passion about and understand really, really well. So it's fantastic for us to have you on the call.
Thank you so much. I really appreciate that. So I'm just going to go through very briefly some recent legal updates. I'm not going to talk about the stuff that's happened previously because I think we're all really up to date with that. So I'm going to start with legal aspect of electrical safety. So first of all, the electrical safety regulations came into existence on the 1st of June. Now, there were some issues. Whoever's, can they mute themselves, please? I can't hear my, no, thank you. So on the 1st of June, the new legal safety regulations came in for electrical safety in single lets of private rented accommodation. Now, there was some real issues over this because the legislation that came out was very different to the guidance that then came out that the government wrote on their own legislation. So that was then withdrawn because the dates were wrong, and then it was reissued, and then it was withdrawn, and then it was reissued, and it was still wrong, then it was withdrawn, and they haven't reissued. But from what we understand moving forward is all new tenancies signed on or after the 1st of June require a 5-year electrical safety test. Now, this must meet the 11th edition of the wiring regulations. So anything that happened, so for example, if you've got a new build, anything that happened prior to the 1st of June may need to be updated if it doesn't meet the 18th edition. That's going to be really important. And there's also a British safety standard mark to that as well. So you have to make sure that it meets your 18th edition British safety standard mark. Now, we were aware that there was a 1-month transition period that took us up to the 1st of July. And I've seen on social media, a lot of people have misinterpreted this, thinking that the law came in on the 1st of June, meaning it affects tenancies from the 1st of July. This isn't the case at all. It was just a transition period to get your certificate done by the 1st of July. Moving forward, it will affect all tenancies from the 1st of April 2021. So whether you are on a fixed term or whether you are on a periodic or whether you are renewing, it must be there by April 2021. I have done a webinar on this on YouTube, and I've just got the link there if you want to have a look at that, because it gives a little bit more detail into the regulations. Then I'm going to move on to the tenant fee ban. Now, we all know that that came into force on the 1st of June last year, but a lot of people forgot that the rest of that legislation became law as of the 1st of June this year. So regardless of what your tenancy agreements currently say, if you've got a clause in there that talks about, you know, a £30 fine for losing keys, or, you know, a pet deposit or something like that, they are now null and void in your tenancy agreement. Your tenancy agreement as a whole is still absolutely current and legal, but the certain terms within your tenancy agreement will now be void and unenforceable. So it's just a reminder really that that now affects all tenancies from the 1st of June 2020. Now I'm going to move on to gas safety inspections, because this created a bit of a headache, and I have to admit I got extremely excited when this finally came to fruition and went to the Court of Appeal and we got the announcement last week. So as we all know, don't we, that due to the Deregulation Act in 2015, it stated that Section 21s were not valid if a gas safety inspection certificate had not been issued to a tenant prior to the tenant moving into the property. Now, this was backed up by a court, a county court decision from Caradon Property versus Monty Schultz, and you'll normally hear it just bandied around as Monty Schultz rather than the whole Caradon versus. And this basically agreed with the legislation saying if there's no gas certificate served prior to occupation, then the Section 21 was invalid, and you've basically promoted your tenancy to an assured tenancy from an assured short hold, meaning you can't use Section 21 and you must use a Section 8 to evict your tenant. So that's how we all worked moving forward. However, come January 2020, Trecarrell Housing Limited and Rounce was the tenant, went to the county court and argued this. And that then went along to the Court of Appeal. Now, the Court of Appeal obviously trounces anything that happens in the county court. And it basically said, the shortened version is, as long as a gas certificate was carried out prior to the tenant moving into the property, but you just forgot to give it, you can remedy this by giving the gas certificate prior to the Section 21 being served. However, if no gas certificate was carried out prior to the tenant moving in, you cannot remedy this by just serving a valid up-to-date gas certificate. So that changed everything that we understood about the Deregulation Act, and it changed everything that we understood about the case law from Monty Schultz. So what this will mean moving forward is landlords can remedy, like they can with every other piece of legislation, such as you can remedy not protecting the deposit by either protecting it or returning it, and you can then serve your Section 21. So it will be along those same lines. The issue we've got is this is only the Court of Appeal, so it can still be appealed and go to Supreme Court. So Rounceville, the tenant, can still take this further and have this superseded, but it's unlikely. It's unlikely because at the end of the day, what is that tenant really going to win? It's just going to be a little bit more time, and I'm sure given the opportunity, Trecarrell House Limited will find a ground under Section 8 to evict. So it's just knowing moving forward you can remedy that Section 21 and gas certificate situation. Then I'm just going to move on to the extension to eviction suspensions. As we know, when lockdown happened, the courts were all suspended and evictions were banned. That's all we heard. Everyone is banned from being evicted. We're all terrible landlords. We can't evict anybody and everyone must live rent-free. This was up till the 30th of June. However, that's now been extended to the 24th of August. Now, what we do know from the announcements today is all courts will reopen on the 24th of August. We're not going to have any more extension to that. So any services of notices that happened prior to lockdown, during lockdown, and you've put your application into court, those will start to be processed from the 24th of August onwards. What we don't know is how long that process is now going to take. There is currently a backlog of around 62,000 cases sitting in limbo in court at the moment. Some of those cases were prior to COVID, so were just general rent arrears or antisocial behaviour, and a number of those have been additional to COVID and have been COVID influenced. What we do know is that courts are going to try and carry out about 10 cases a day, and they're going to try and do that via virtual phone calls or videos or phone calls. So it's all going to be as virtual as possible. Now, the logistics of that is going to be horrendous because, as we all know, if any of you have stood in court waiting for a judge, lots of cases overrun. So how are we going to be in a position to get a landlord, a tenant representative, a landlord representative, all on the phone line, all at the same time, just as the judge is ready? Don't know how that's going to work logistically, so it's going to be a bit of a suck it and see situation. Now, the one thing I do just want to reiterate to everybody is, although the courts open again on the 24th of August, you can still serve notice on your tenants now, and you have been able to all through lockdown. The only difference has been that the notice now must be 3 months notice, as opposed to either 2 weeks, 2 months, when it was a Section 8 or a Section 21. And that 3 months notice period continues until the 30th of September. Now, it's possible the government will revise the 30th of September and say that 3 months notice is going to be extended. So you can continue serving 3 months notice maybe until December. We don't know. But 3 months notice will continue to be served until the 30th of September. The other thing I just want to bring to your attention, which I've seen on social media a lot of misunderstanding, is a Section 21 only has a 6-month shelf life, and then basically it turns into dust. So if you've served a Section 21 with 2 months notice prior to lockdown, let's say in January, you've only got 6 months to take your application to court to make sure that you then get your possession order. Now, once your application goes to court, your 6-month clock stops. But what I've been seeing a lot of landlords misunderstanding is they've served their Section 21, their Section 21 has expired, and they don't think they can put the application in until the courts reopen on the 30th of June or now the 24th of August. If you've served in January and you're waiting to put your court application in for the 24th of August, your Section 21 has expired. It's no longer valid. It's now dust. You cannot put an application into court. So it's really important to know when you served it, the date you served it, know you've only got 6 months to put your application into court. After that date, you have to start the whole process again. So you'd have to start with a new Section 21, a new 3 months notice, wait for that to expire, and then put your application in. So that's all I've got to say for this evening. I'm done. See, I don't take up the time like Sam does. So that's me done for this evening. If anyone's got any questions, then I'm more than happy to answer them. And I hope that was clear as mud for everybody.
No, it's always worthwhile. There's as much there's as much value as in yours as Sam, so that's really good. It's not a competition, Julie.
It is.
I just wondered, are there any questions from anybody on what Julie's just presented? Oh, there's a bravo from Richard, which is really lovely. So I think that it's important to be aware of, particularly the time into the Section 21. That was really important, Julie. So thank you for that. And obviously with the court cases for the gas safety certificates, it's getting, we do need to be on top of this to stay legal and be good landlords, I think, and make sure we can use the law effectively when we need to. So it's all really important, and it's quite a change in sort of volatile field, really. So it's great you keep us updated there, Julie. So thank you very much.
No problem.